The moment of confrontation, when a recovery agent arrives at your doorstep with the intent to seize your vehicle, a critical moment unfolds. The line between lawful recovery and illegal seizure hinges on procedure, authority, and adherence to established guidelines. Under Indian law, recovery agents operate within a carefully defined framework. They cannot simply arrive and take your car without following mandatory legal procedures. The Reserve Bank of India has established comprehensive guidelines that govern how recovery must occur, and any deviation from these procedures constitutes harassment and potential criminal conduct. The search results available focus primarily on loan recovery harassment through contact violations and misconduct by agents. However, they do not directly address the specific scenario of forcible asset seizure. What the sources do establish is this crucial principle: recovery agents must follow strict procedural requirements. The SARFAESI Act, which governs asset recovery, requires proper legal notice, borrower hearings, and objection periods before any seizure can occur. For secured loans below 2 lakh rupees, SARFAESI provisions do not even apply, providing additional protection for smaller borrowers. The legal framework protecting your asset recovery agents cannot seize assets immediately, regardless of what they claim. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act contains explicit procedural safeguards. Before your vehicle can be legally taken, the lender must provide written notice. This notice must give you a reasonable period to respond and object to the proposed action. You have the legal right to be heard before any seizure occurs. The RBI Guidelines mandate that lenders provide 30 days written notice before appointing recovery agents. This protection exists specifically to prevent the very scenario you face. If recovery agents appear at your residence without this preliminary notice, or without your lender having followed proper procedures, their actions constitute violations of established regulations. Documentation becomes your shield. The moment an agent appears, you should demand proof of authorization. Recovery agents must carry official identification cards and authorization letters from your lender. These documents must be authentic and verifiable. The guidelines require that every interaction between you and recovery agents be digitally documented, whether through calls, messages, or visits. The critical first response: when recovery agents attempt to seize your vehicle forcibly, your immediate response determines the strength of your legal position. Do not physically resist, as this can lead to charges against you and create complications in your subsequent legal action. Instead, document everything. Record the date, time, names of agents present, vehicle details, and the exact actions taken. If possible, use your phone to record video or take photographs of the agents, their identification, and the seizure process itself. Demand written documentation from the agents before they take possession of your vehicle. Request their authorization letter from the lender and their identification credentials. Photograph or copy these documents. The absence of proper documentation at this moment creates a strong foundation for your legal claim. Under RBI guidelines, recovery agents must maintain records of every interaction, and the lender must provide these records upon request. If the seizure proceeds without proper written authorization, this becomes evidence of unlawful action. Immediately notify relevant authorities within hours of the seizure. File a written complaint with your lender's grievance redressal cell. The RBI guidelines require lenders to maintain in-house grievance mechanisms. Your complaint should detail the date, time, agent names, and the unauthorized nature of the seizure. Request confirmation of whether proper SARFAESI procedures were followed before the seizure. Simultaneously, contact the Banking Ombudsman or RBI Integrated Ombudsman depending on your lender's category. The response time for the Ombudsman is typically 30 days. Include in your complaint specific details about whether the lender provided the mandatory 30-day notice, whether proper hearing procedures were followed, and whether your objections were considered before seizure. If your lender cannot produce proper documentation showing compliance with SARFAESI procedures, this constitutes a violation. The Ombudsman has authority to direct lenders to restore seized property when procedures have been violated. The civil injunction route. Your most immediate legal remedy is filing for a civil injunction against the lender and recovery agents. Approach the civil court in your jurisdiction with an application for interim relief seeking the restoration of your vehicle. Courts have repeatedly recognized that seizures conducted without proper legal procedure violate constitutional protections. Article 21 of the Constitution guarantees the right to protection of life and personal liberty. Your property rights fall within this protection. In your court application, argue that the seizure violates SARFAESI Act provisions. If you received no 30-day notice, if you were not given opportunity to be heard, or if agents used force to take your vehicle, these facts constitute procedural violations that courts recognize as grounds for interim relief. The burden shifts to the lender to prove that all procedural safeguards were observed. Most lenders cannot produce this evidence when seizure was conducted hastily or outside legal channels. Criminal remedies for forcible seizure. Forcible seizure of your property without legal authority may constitute criminal conduct under Indian Penal Code provisions. Section 504 of the IPC addresses criminal intimidation through threats of injury to person or property. Section 506 addresses criminal intimidation where threat is made with intent to cause fear. If recovery agents use threats, abusive language, or physical force during the seizure, these actions may violate these sections. File a police complaint detailing the conduct of recovery agents. Specify that they threatened you, used abusive language, or used physical force. If the seizure involved trespassing onto your property without permission, this may constitute additional offenses. The police have authority to file cases against recovery agents for criminal intimidation or harassment. While police action may seem slow, the filing of an FIR creates an official record that strengthens your civil and ombudsman complaints. The tort of conversion beyond the IPC and SARFAESI violations. The forcible taking of your vehicle may constitute the tort of conversion under tort law. Conversion occurs when someone unjustifiably deprives you of possession and use of your property. If the seizure was conducted without legal authority or proper procedure, the lender and recovery agents may be liable in damages for conversion. File a suit for damages in the civil court claiming compensation for the wrongful seizure of your vehicle. This suit should quantify not only the value of the vehicle but also damages for loss of use, inconvenience, mental anguish, and any consequential losses resulting from the vehicle's seizure. Courts recognize that wrongful deprivation of essential property causing substantial inconvenience warrants significant compensation. Building your evidence file from the moment seizure occurs, create a comprehensive record. Collect bank statements showing your payment history. If you were current on payments or the default was minimal, this demonstrates the seizure was premature. Gather any communications from your lender confirming your account status. If the lender sent no 30-day notice, the absence of this document is itself evidence of violation. Document any medical emergencies, job loss, or personal circumstances that caused the default. Courts and ombudsmen consider hardship circumstances when evaluating the proportionality of recovery actions. If your seizure resulted from temporary financial difficulty, this context strengthens arguments that forcible seizure was excessive. Preserve all communications with recovery agents. Any threatening language, abusive conduct, or demands that violated RBI guidelines become part of your evidence. Screenshots of threatening calls or messages are admissible in court. Expert evaluation of procedures before your court hearing. Obtain legal advice from an attorney experienced in banking regulation and consumer protection. Request that your attorney analyze whether the lender followed SARFAESI procedures. This professional evaluation becomes evidence in your case. Many violations of the Act are technical but consequential. An attorney can identify specific procedural gaps that the court will recognize as grounds for relief. Escalation through administrative channels. If ombudsman complaint and civil suit proceed simultaneously, the ombudsman may achieve faster resolution. The RBI Ombudsman has authority to direct lenders to take corrective action, including restoration of wrongfully seized property. Present to the Ombudsman the complete documentation of procedural violations. Include the SARFAESI Act requirements in your complaint, explaining precisely how the lender deviated from mandatory procedures. Many lenders, upon receiving an ombudsman complaint, recognize the weakness of their position and take steps to return seized property rather than proceed with protracted litigation. The ombudsman process is free and moves faster than civil courts in many jurisdictions. Negotiated settlement throughout this process. Maintain communication with your lender offering to resolve the underlying default through negotiation. Many lenders will reconsider aggressive recovery actions when faced with legal challenges to the seizure itself. If the seizure was the result of overzealous agents rather than deliberate lender policy, the lender may authorize the agent to return your vehicle in exchange for a structured repayment arrangement. Propose a settlement that addresses both the underlying loan default and the wrongful seizure. Seek return of your vehicle and agreement to modified repayment terms that account for your financial circumstances. Document any such agreement in writing to prevent future disputes. Prevention of permanent loss. If the lender has already sold your seized vehicle or transferred it to a third party, your remedies become more complex but not impossible. You can pursue damages claims for the full value of the vehicle plus consequential damages. You can also seek punitive damages against the lender for gross procedural violations. While recovery of the vehicle itself becomes impossible, substantial financial compensation becomes available through the court system. The essential principle remains constant throughout these processes. Recovery agents and lenders do not have unlimited authority to seize property. The law provides multiple layers of protection through administrative procedures, civil remedies, and criminal provisions. Your role is to activate these protections immediately and comprehensively when unlawful seizure occurs.